Hello, welcome. Today we have a KCA virtual presentation. It's on how contractors can prepare for the Davis-Bacon updates. As you probably know, earlier this year, President Biden signed an executive order to change Davis-Bacon rules and payments and penalties and all that good stuff. So there's a lot of questions for employers. Open shop, union, everyone kind of wants to know what's going on. And who better than our good friend out west, out in Pittsburgh, to give us the update here. Matt Jameson from Burns White has volunteered to help us out and steer us in the right direction here. So without further ado, if you have questions during the presentation, feel free to put them in the chat, or the best way is just kind of raise your hand and we'll acknowledge you. And I'm sure Matt is willing to accept questions on the fly during his presentation. But if I'm wrong there, I'm sure he'll correct me. So without further ado, Mr. Jameson, take it away.
All right, thanks, John. Appreciate it. And certainly I'm more than happy to respond to any questions during the webinar today. So we've got a small enough group. If anybody has questions, just feel free to chime in, and I'll try to address them as I proceed through the materials. But thank you to John and Seth with the Keystone Contractors Association for the opportunity to discuss the recent rule that implements significant changes to the Davis-Bacon Act. I hope you find this information informative. And again, I'd encourage you to ask questions while I review the material. If you have any questions afterwards, you're more than welcome to follow up with an email, and I'll get back to you right away. It's just DM Jameson, Jameson at burnswhite.com. So to kick things off, just in terms of a brief overview, the Davis-Bacon Act requires contractors and subcontractors working on federally funded projects, anything over $2,000. So obviously pretty much any construction project that receives federal assistance to pay employees no less than local prevailing wages and fringe benefits for the work on similar projects in the area of the project at issue. Now, the rule was first proposed in March of 2022. And when that rule came out in draft form, it generated a significant number of comments because the rule does dramatically expand the scope of the Davis-Bacon Act. The rule was ultimately finalized and published on August 23rd and actually went into effect on October 23rd, so just 2 days ago. This is the biggest overhaul to wage determinations under the Davis-Bacon Act in decades. A couple other points I wanted to highlight for you on this slide. The application of the Davis-Bacon Act applies to federally assisted projects. In other words, the project does not have to be funded entirely by the federal government for the Davis-Bacon Act to apply. And to give you a sense of the breadth of the application of the Act, it is estimated to apply to over $217 billion in construction spending in the upcoming year, and an estimated 1.2 million U.S. construction workers. So it's obviously a big issue. As I'm sure many of you are aware, recently, within the past year, a contractor in Central PA pled guilty to violations of the Davis-Bacon Act and paid over $20 million in back pay to over 1,200 employees. And I just highlight that for you to stress the importance of your compliance with this act. And it's going to be really important for everybody to be aware of these recent changes so that you can ensure that you are, in fact, complying with the act. Now, to give you, in terms of a general overview of the biggest changes to the act expands the definition of building or work to include renovation work, so it doesn't have to be new construction. It expands the site of the work to include significant portions of the work that are constructed off-site. And we're seeing, obviously, more and more of that in the industry, so we'll talk about that in a little bit more detail. It also changes how federal wages for, how prevailing wages for federally funded construction projects are calculated. And it's actually sort of a back to the future We'll see that in a minute because the act now returns to the prior rule that they used to have. So when you look at the area definition, some of the biggest changes are that the changes to the calculation includes alternatives to the existing definition of area. Specifically, it includes multi-county, where project wage determinations, where all involved counties' data is combined to develop a single wage rate for the project. And also that the wage and hour division may use state DOT highway districts, for example, the various districts within PennDOT, or similar geographic subdivisions when you're talking about highway category construction. So you're not necessarily going to be limited to looking at a county by county basis for a highway project. It may make more sense to consider a DOT PennDOT division when determining the scope of the prevailing wages for a particular project. The rule revisions also eliminate the ban on mixing rural and metropolitan data that used to be in place. Surrounding counties may now be used when data is not sufficient at a county level, regardless of rural or metro designations. So there historically has been, pretty significant wage differences between metro and rural areas. And historically, you haven't been able to combine those areas. Now you can. And in fact, rural and metro data can be combined at a supergroup or statewide level. That's a last resort before determination that no sufficient data exists for a particular project. So as I mentioned, in terms of back to the future, the new rule returns the Davis-Bacon Act prevailing wage standard to that which was applied between 1935 and 1983. And specifically, there's now a three-step prevailing wage definition. Step one is if a majority, 50% of wage rates are the same, then that is the prevailing wage. If there is no majority, then the prevailing wage, that is the rate earned by the greatest number of workers, will be the prevailing wage, provided that at least 30% of the workers earn that rate. And you'll see that referred to in discussions regarding the Davis-Bacon Act as the 30% rule. And it's only if no wage rate is earned by at least 30% of the workers, then a weighted average will be used. So that's obviously a significant change from the definition that we've been using since 1983. I also wanted to note that this same definition applies to fringe benefits. If 30% of the workers receive a certain fringe benefit, then that is the prevailing fringe wage rate that will be applied on that particular project. Now, the AGC and several other construction trade groups have objected to the method of determining applicable wages, and they've objected to this. Specifically, the primary objection has been to the 30% rule. But as I said, the Department of Labor determined to ignore those objections and return to that historic definition. The new rule also revises the definition of prime contractor to mean any person or entity that enters into a contract with a government agency. I also, a couple other points I wanted to note in terms of the application of the new rule. The new rule clarifies that it applies to a surety that is completing performance for a defaulted contractor pursuant to a performance bond. I'd also note that the definition of prime contractor is certainly now broad enough that it could include a developer or another entity that has historically not been viewed as a contractor. Now, the revised definition also includes the controlling shareholders or members of any entity holding a prime contract, the joint venture or partnership holding a prime contract, and any contractor that has been delegated responsibility for overseeing all or substantially all of the prime contract's anticipated construction. And basically, when you look at the changes to the definition, most of the people that have commented on this have indicated that the changes to the definition are stated to be for the purpose of preventing the use of single-purpose corporate entities to avoid liability. We've obviously seen that on a number of large projects where a new special purpose entity will be created. And then if there's a problem with compliance with the Davis-Bacon Act, that single purpose entity sort of throws up its hands and indicates that they don't have any assets sufficient to respond to that liability. Well, under this expanded definition, you could be looking at liability to the controlling shareholders of that special purpose entity. As I noted earlier, the new definition is broad and could potentially include entities such as developers. And some commentators have even noted that liability could extend to personal liability for shareholders, particularly of a special purpose entity, for violations of the Davis-Bacon Act. I also wanted to note that the definition is very clear that it's going to apply to subcontractors of any tier. So it's not just a question of, whether you're first tier or second tier subcontractors. Now, the new rule reverses longstanding precedent that Davis-Bacon obligations are not self-executing and must be determined to apply to a contract. Under the new rule, obligations under the Davis-Bacon Act are effective as an operation of law, even if they are not attached or specifically referenced as being included in a contract. The Department of Labor, in fact, can retroactively find that contracts are subject to the Davis-Bacon Act obligations. And so this could create sudden back pay obligations and increased costs going forward under a contract. Now, it's important to note that a contractor must be compensated by the owner if the prevailing wages are applied retroactively. Typically, that would be done via change order. That being said, if you are bidding a job that does not require prevailing wages, but there's an argument that the Davis-Bacon Act applies, I would recommend that you either clarify in a pre-bid question whether the act applies or not. And if the indication is that it does not apply, you should clearly indicate in your bid that you are not basing your bid on prevailing wages, so that if it is ultimately determined that prevailing wages apply, that you would be issued a change order to compensate you for the increase in wage costs. I wanted to move on and talk about the expanded definition of site of the work, specifically as it relates to secondary sites. The new rule revises the definition of site of the work to include any site where a significant portion of a building or work is constructed, providing that the site is dedicated exclusively or nearly exclusively to the performance of a single Davis-Bacon Act covered project for a period of time. And really this, if you look at this, for example, in the area of bridge construction, there are a lot of projects where there may be a separate area of work where significant portions of a bridge structure are being constructed specifically for use at the project at issue. In that circumstance, that secondary location, which referred to as a quote secondary site, will be determined to have a Davis-Bacon Act wages apply. Now, the period of time must be in use for more than a few hours or days of temporary use. This is really talking about the situation, like I said, where a work area at a particular site may be limited. So to address that concern, there is a secondary site that is used to construct significant portions of the project, but it is not within what has historically been viewed as the site of the project. In that circumstance, that secondary site is going to be determined to have Davis-Bacon Act wages apply. And I would also note there's a real distinction here between general non-project specific materials where the Davis-Bacon Act clearly does not apply, and project specific prefabricated components where the Davis-Bacon Act would apply. So the one example that is referenced in the comments relates to the use of prefabricated housing components that are really just a commodity-based product and sold as a material. That is not, the Davis-Bacon Act is not going to apply in that situation. It really has to be a project-specific material, and more than that, a project-specific secondary site. Now, I wanted to discuss briefly flaggers, because that has been a change under the new rule. Flaggers are considered to be working on the site if they work at a location adjacent or virtually adjacent to the primary construction site, such as a location a few blocks away or a short distance down a highway. Obviously, you're seeing this more on highway construction projects where you could have flaggers that are, somewhat distant from the project site, but are clearly working specifically for the project that is a Davis-Bacon Act project. You would have to pay Davis-Bacon Act wages to those flaggers in that circumstance. Now, next I wanted to touch on survey crews. And on survey crew members, it really depends on the relative importance of the workers' different duties, including time spent performing their duties. So survey crew members who spend most of their time taking measurements would likely be deemed laborers or mechanics, and would not be exempt as a professional, executive, or administrative employee under Part 541 of the Fair Labor Standards Act. Under that act, you're really talking about the professional surveyors who are taking the data generated by the survey crew members and preparing survey work. Case-by-case status evaluation will be necessary depending upon the work performed. But again, you want to be clear as an employer that you are making an effort to distinguish between the crew members who are primarily taking measurements. Again, they would be covered by the Davis-Bacon Act, and the professionals, professional surveyors, registered surveyors, who would likely be exempt from application of the Act. Now, in terms of truck drivers, the new rule requires that truck drivers must be paid applicable prevailing wage rates for all on-site time related to off-site delivery if such time is not de minimis. Now, de minimis is not objectively defined. It is more of a subjective standard, where significant portions of a driver's day or week are on-site. Short periods of de minimis time may be combined. And also there's a determination of whether on-site time is de minimis is based on the total time spent on the work site during a typical day or week. So again, I think you've got to look at this as an expanded definition of truck driver application of Davis-Bacon Act wages. Practically, the liability for non-compliance may be difficult to establish due to poor records. One of the things, though, that I'm encouraging clients to consider are the potential use of GPS information. Obviously, most trucks now are equipped with GPS data, and it certainly may be possible to go back and calculate the amount of time that a driver was spent on a project site. Most commentators on the new rule have indicated that they are hopeful for future guidance on this issue related to the degree of accuracy and precision of records that an employer must maintain to ensure that they're complying with Davis-Bacon Act requirements as it relates to truck drivers. Now, I mentioned this earlier, but material suppliers are expressly included from the definition of contractor under the rule. The definition of material suppliers under the rule includes entities whose contractual responsibilities are limited to the delivery of materials and or supplies and related incidental activities. An entity solely engaged in pickup and haul away activities is not a material supplier. And I think your focus on this needs to be on whether the deliveries are of general construction materials, the types of things that you're going to need on every construction project that are really commodity-based materials, as opposed to project-specific items that have been constructed and are being delivered to the project site. In that circumstance, there's more likely going to be a determination that the Davis-Bacon Act applies as it relates to that project-specific component. Now, historically, there's been a 20% threshold under which a certain amount of non-delivery on-site construction work could be performed while remaining as classified as a material supplier and therefore not under the Davis-Bacon Act requirements. Now, instead, under the final rule, any entity that engages in other construction work at the site is not a material supplier, but is a contractor or subcontractor for Davis-Bacon Act application purposes. Now, at this stage, it is unclear where the line between incidental activities and construction work begins and ends. The Department of Labor has yet to officially opine on whether activities such as advice, and instruction of use for materials is construction work or not. The Wage and Hour Division, in fact, was directly asked in the comment period where the line for construction work was and whether advice and instruction counted. And the Wage and Hour Division refused to opine on that, instead referring the question back to the rule's preamble in terms of what the intent of the Davis-Bacon Act is. So for that purpose, I would recommend that if you have questions about how materials should be used on a particular project, frankly, you're probably better off resolving those with your material supplier over the phone and not engaging in those discussions at the project site for fear that suddenly that material supplier is going to be classified as a contractor or subcontractor and therefore subject to Davis-Bacon Act wages. So record keeping. The Wage and Hour Division's longstanding policy permitting certified payrolls to be signed and submitted electronically is now codified by the final rule. The final rule adds a requirement that all contractors and subcontractors need to retain Davis-Bacon Act contracts and related documents, including worker telephone number and email addresses, for a period of at least 3 years from the date all work on the prime contract was completed. The failure to timely produce records as part of an administrative claim could result in the bar on the use of those records during later stages of the claim, including in front of the appeals board. Now, obviously, that third point, the concern is they don't want employers fabricating those records after the fact. They want you to be able to produce them promptly in an administrative claim proceeding. So one of the issues, and I've been touching on this point when I've been talking to clients about this new rule, is, everybody is very aware of the risks of cybersecurity and, what potential breaches. I'm sure most people are aware of the Johnson Controls data breach that Johnson Controls has been dealing with, where they're being held hostage with respect to what are potentially sensitive government records that they had stored electronically and were hacked by a hacker. So how do you balance those cybersecurity concerns with the record-keeping requirements of the Davis-Bacon Act? And my advice to clients are, look, under the Davis-Bacon Act, you are required to retain this information. Obviously, it's most easy for companies to retain this information electronically. That being said, you certainly don't have to keep it on a server. You can, once a project is over, and you need to maintain this for 3 years, keep it electronically, but download it and get it off your server. Keep a couple different copies of it in different locations so that you can access the information quickly as required by the Davis-Bacon Act, but don't have it available on your server so that if you get hacked, now you've got employee telephone numbers and email addresses that were hacked, and you have all of the problems associated with dealing with that potential disclosure of confidential information based on a cybersecurity breach that you wouldn't have to deal with if you would just remove that information from your server. So I'm encouraging clients to take that step as it relates to record keeping. A few other points with respect to record keeping. The failure to retain and produce records could potentially result in debarment. The contractor that I mentioned earlier in Central PA who pled guilty to violations of the Davis-Bacon Act is now dealing with the potential debarment as a result of those violations. So that's a significant concern that you need to be aware of. Particular attention must be paid to whether a project is subject to the Davis-Bacon Act, and your record keeping measures should be universally improved to comply with the Davis-Bacon Act requirements for all federal projects to avoid any risk of debarment. So again, you've got to maintain those records. Again, I would recommend that you maintain them off of a server that could be hacked in the event that you're dealing with a cybersecurity issue. And there's another provision that was added in the new rule regarding an anti-retaliation provision. And this applies to all contracts that are subject to the Davis-Bacon Act. Remedies for violation of the anti-retaliation provision are designed to, quote, make whole the worker and restore them in terms of work and employment status to where they stood pre-retaliation. And these remedies include, but are not limited to, back pay and benefits denied or lost, monetary or compensatory damages, interest on back pay and other relief, such as equitable relief, including reinstatement and or promotion. And the exact quote in the rule, just so you're aware of it, it says that it is, quote, unlawful for any person to discharge, demote, intimidate, threaten, restrain, coerce, blacklist, harass, or in any other manner discriminate or cause any person to do the same against any worker for engaging in a number of protected activities under the Davis-Bacon Act. And those activities include, quote, notifying any contractor of any conduct which the worker believes reasonably constitutes a violation, filing any complaints, initiating or causing to be initiated any proceeding, or otherwise asserting or seeking to assist any right or protection, cooperating in any investigation or other compliance action, or testifying in any proceeding or informing any other person about their rights under the Davis-Bacon Act. So again, this is a very broad provision, and you're going to want to be very careful that there's not even an appearance that there's a retaliation against an employee for protecting their rights under the Davis-Bacon Act. The debarment rules, I wanted to touch on those. The new rule creates a uniform debarment standard covering both the Davis-Bacon Act and related acts by eliminating the heightened, quote, aggravated or willful debarment standard in favor of the DBA's lower, quote, disregard of obligation standard. So under the old standard, you basically had to prove intent, almost that someone was trying to avoid the application of the Davis-Bacon Act. Under the new standard for debarment, the government agency would just need to demonstrate that there was a disregard of obligations under the Davis-Bacon Act. Similarly, the Davis-Bacon Act's mandatory 3-year debarment period now applies to related acts and eliminates the possibility for early removal from the list, which existed pre-rule. Okay, so what are the takeaways from the points that we've discussed so far today? It's extremely important to participate in wage determination surveys to ensure that your wage data is counted for wage determination under the Davis-Bacon Act. These surveys are akin to your vote in the final wage determination. So I certainly would encourage you to participate in those surveys to the extent that you receive them. Review each contract for Davis-Bacon Act applicability, and if unsure, remain in compliance with DBA regulations as a protection against future potential liability. Establish increased record-keeping standards to ensure compliance with both site of work and retention requirements, and ask questions to stay up to date on the new guidance from the Department of Labor. The AGC has done a real nice job in publishing a bunch of information with respect to applicability of the Davis-Bacon Act. And the new rule is complicated. You know, we've really just touched on the highlights from the new rule this morning. And if you are unsure how to approach a DBA-related situation, certainly consult with legal counsel. I know John and Seth at the Keystone Contractors Association are staying aware of these revisions, so they would be a good resource for you as well. But it's going to be important that you stay on top of these issues moving forward to avoid potential liability for violation of the Act. So, been through a lot of material here this morning. Wanted to open it up to questions to the extent anybody has any.
Be shy. Who's got a question here? Real quick, maybe I'll get it started or break a little ice here. So the developer, you mentioned a few times about the developer statement and might get pulled into this. Is that related to grant money and getting grants for projects?
Yes, you know, and really, the way that we've seen a lot more of the federal projects get procured based on a proposal process, and even, you know, the expanded use at the federal level of design build projects, we're starting to see developers be frequently the entity that contracts with the federal agency, and then things are handled on a design build basis from that point. So you certainly have the potential for application of Davis-Bacon Act wages to entities that historically have not been viewed as contractors.
Nice. And then Davis-Bacon Act applies to direct employers, and you mentioned how it goes down to the tiers, to the various subs and primes.
Right.
So a general contractor, for example, cannot be held liable for a second tier sub, you know, not following Davis-Bacon, correct?
Well, unless they had knowledge of it, correct,
Okay.
John,
Yeah.
correct. But if they had knowledge of it, then there certainly is the potential for liability, upstream liability. So, you know, especially as it relates, and a lot of the issues that you've looked at historically for violation of the Act relate really to classification of employees.
Mm-hmm.
And I think you need to be careful with that, you know, even to the extent you're dealing with subcontractors, because if you've got knowledge, you know, based on payment applications that a subcontractor is classifying an employee the wrong way, you know, I think you've got to be careful of exposing yourself to liability there.
Oops, I just muted someone. I heard some mumbling in the background. Now it looks like we have a question in the chat here. Let me open up my chat here. In regard to the drivers, is it possible that ready-mix concrete drivers will be subject to DBA moving forward due to time spent on the job? Will there be guidance for this?
I'm sorry, John, could you repeat that one more time for me?
Yeah. In regard to drivers, is it possible that ready-mix concrete drivers will be subject to DBA moving forward due to time spent on the job?
Yes, I think that's a very significant concern, and part of the reason why there were a lot of questions to the Department of Labor during this rulemaking process, you know, over the past year about, can we have more details, you know, on how you're going to be applying this for those types of concerns. And basically the Department of Labor just punted on it and said, you know, we're not going to respond to that with an objective standard. We're going to see how the new rule works in operation, see how employees are applying it. I think the focus is going to be on time spent on the project site. So when you look at to address that specific question, if you've got a delivery driver that by nature of the delivery is going to be required to spend significant more time on site, I do think you have to be concerned about the application of Davis-Bacon Act wages to that driver.
And there's a part two to that. According to your response, this is still early in the phase and early in the process. But do you anticipate guidance coming?
I do.
Yeah.
I think that there were enough questions on that particular issue that there's going to be so much uncertainty in the field that I do think the Department of Labor is eventually going to have to issue some supplementary comments specifically addressing that issue. And in the meantime, I think the best approach, again, a lot of this goes back to record keeping. You want to be in a position where if retroactively the Department of Labor says, well, no, you should have been paying Davis-Bacon Act wages to this driver based on the amount of time they spent on site, you can easily go back and say, okay, all right, well, I can tell you exactly how much time they were on site based on GPS records or some other records that you have. And we are now prepared to pay those wages. And, here's what the wages are. And by the way, Mr. Owner, we're entitled to a change order for those additional wages because we had no reason to believe that they applied at the time the employee was originally paid.
Good stuff. Bill, who submitted that question, I'm assuming you'll type another chat if you need follow up to that response or whatever, or hopefully that answers your question. If not, I'm sure we'll hear from you. Anyone else from the crowd here? Any other questions? Comment? Bill says, "Thank you, Matt. That's good. Good stuff."
All right.
Yeah.
Hey, Matt, it's Joanna. I have a quick question.
Oh, hey, Joanna.
How are you?
Good. How are you doing?
Good. So on the record retention and sort of data privacy stuff, I assume the Davis-Bacon Act doesn't have any sort of requirements that it be maintained in a specific form. So housing it off server and just having it accessible within the Davis-Bacon Act requirements would be sufficient to protect us from the privacy issues.
Correct. Exactly.
Okay.
Exactly. Yeah. Really, the requirement that they focus on is the ability to access it quickly because,
Okay.
I think they're worried about employers fabricating this information after the fact. But obviously, if you're storing it off site, you still got the ability to access it immediately. It's just not going to be sitting on your server.
Okay. And then are you seeing or have any thoughts on like improved contract language that would further protect the data in light of sort of what happened with Johnson Controls and otherwise, or just sort of standard protections?
Yeah, that's a good question. Yeah, that's a good question. I think addressing that issue contractually makes sense.
Yeah.
Because again, you're doing it for a very reasonable basis. So
Okay.
if you indicated in your contract that we are going to comply with the requirements of the Davis-Bacon Act, but we will be storing this data, for example, on a drive that is going to be maintained off-site, so that you're upfront about it. We're being real clear why we're doing this. We're concerned with protecting, on one hand, protecting the privacy interests with that data, and on the other hand, complying with the Davis-Bacon Act.
Yeah. Okay.
The other thing that employers may want to consider are, the Davis-Bacon Act is pretty clear in terms of what you have to retain, address, phone number, email. If all of that data is lumped in with other additional data that you have with respect to your employee, that's all the more reason to get it off of your server, or if there's a way that you can separate it so that you're retaining the information that the Davis-Bacon Act wants you to retain without retaining additional information that where there may be greater privacy concerns. For example, social security number.
Okay, great. Thanks, Matt.
Sure.
Good questions. Anyone else? Any good questions? Any or not any questions at all? Any comments, feedback? I just think the information was so good, you just overwhelmed them with such good knowledge here.
And again, John, I'm happy to respond to anybody, you know, even people that are watching this after the fact. If people have follow-up questions, happy to respond via email.
Yeah.
You know, if you want to include my contact info as a follow-up to you know, everybody that registered, I'm happy to respond to anything via email.
Perfect. You heard it directly from the man himself. So following
people
this,
usually like the opportunity to get free advice from lawyers, right?
there you go. Yes. No, but you always deliver and you give great advice, you know, and good guidance. So unless there's any final questions, and not seeing anyone unmute or seeing nothing in the chat, on behalf of the KCA, just want to thank Matt for spending the time and preparing for today and delivering this information that's very important to construction contractors, and we appreciate it, and keep up the great work.
Absolutely. Thanks again, John. Thanks for having me. I appreciate it.
Thanks. Take care. Have a good
All
day,
right.
everyone.
Take care, everybody. Bye-bye.